Welcome to Ceasefire, where civics meets civility and engagement meets empowerment. Ceasefire is hosted by former Boerne ISD trustee and owner of the Boerne Bookshop, Dale Adams, and by former Boerne City Council member and local insurance agent, Ron Cisneros.
Good morning. Welcome to Ceasefire, brought to you by the Boerne Bookshop. My name is Dale Adams.
And I'm Ron Cisneros.
And today we're going to dive back into the Bill of Rights, about the Fourth Amendment. And I'll just go ahead and read it right here for you, because I'm sure some of you might want me to refresh their memory. So the Fourth Amendment states, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall be issued but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Why would we need to have that actually in our Constitution? That seems so restrictive.
Yeah, it sure does. And in contrast to the last one we did, the Third Amendment, this, as I was doing research for the show, there are a lot of cases that have gone to the Supreme Court about this very amendment.
Yeah.
It's incredible. And it seems, just in what you read, all-encompassing, but it's amazing what wasn't put in there and what was later interpreted from that.
Yeah. And it goes way, way back. This concept of the government can only do so much has been pushed by the lords of England back centuries.
That's
and
right.
It's interesting that it keeps cropping up, and it's still valid.
Yes, it is.
I got a book about that.
All right.
I'll tell you later.
Sounds good. Let's say you want to break it down piece by piece. We can start with the unreasonable searches and seizures by the government.
Okay, sure. We will start with that phrase. Unreasonable. What does that mean? And being reasonable is different for every single person, right? What you consider reasonable is different from what I would consider reasonable. And they do sort of state what it means by saying without probable cause, supported by an oath or an affirmation. So I think that's pretty specific. You have to have something legal, basically.
Let's try and break that down. The police couldn't come into my house just on the assumption that I'm doing something bad. They need somebody needs to tell them something. Maybe they have a reasonable suspicion,
right,
to believe that I'm doing something wrong. And then they have to go to a judge or a magistrate and get a warrant.
Right, where they're going to affirm or swear an oath that what they believe is true, that there's such and such that's in that house.
Yeah, and I'm going to come back to that one a little bit later, because that actually shows up in the Supreme Court somewhere in the late 60s, trying to get that affirmation down, what that means.
Yeah. Honestly, I think the police have probably helped us fine-tune this amendment a lot. And so unreasonable and reasonable actually has specific meanings for them. I think that's been a good thing, actually.
So what does this mean? Some examples are police aren't entering a private residence without a warrant to make an arrest. Police aren't entering a home without a warrant to search for evidence. And police aren't illegally seizing someone. What does that mean? Is it just not grabbing somebody off the streets without some sort of suspicion or something more concrete, I guess?
Right. And it has to be a concrete suspicion, such as this one that's used a lot with cars, is smelling marijuana. And so that's a sense that they can document, and they can say, yes, I smelled this or that. Rather, they can't just say, I think they have something in there because they look like the person that would. Now, honestly, to go too far into that, we'd have to have a police officer to get some specifics, because I haven't been unreasonably searched and seized, so I don't know exactly what kind of process they have to go through for that, but I know it's pretty specific.
Yeah. You know what I thought was interesting, and as I was looking up information for the show, came across a case. This one went to the Supreme Court. This was MAP versus Ohio. This was in 1961, and this established the Fourth Amendment's protections against illegal search and seizure as it applies to state courts. So up until that point, the states assumed that was basically a check against the federal government, not against the state government.
Right. All of them were. They originally all were federal limitations. They weren't state limitations. In fact, we had state churches initially also. But then 14th Amendment, is that what it was? applied all of those to the states. I can't remember which one it was. I think it was the 14th. Was it the 14th or the 15th?
I'm going to defer to you on that one.
Don't, because I'm probably wrong. But I know that one of the amendments around emancipation took all the restrictions on the federal government and applied them to the local governments
That's
also.
interesting. In this particular case, what we had was a woman who was, let's see here, they were looking for a bombing suspect and illegal gambling paraphernalia. They searched her home, didn't find any of that, but they found obscene materials and arrested her based on that. And she was convicted of possessing obscene materials. Now, I didn't get enough information on this to figure out what the obscene materials were. Right. I wish I'd had a little more time to dig deeper, because I'd like to know, in today's world, would we see that as obscene? Yeah.
Probably not. Usually that is time specific, period specific.
Yeah. Anyhow, so she appealed her conviction to the Ohio Supreme Court, which upheld it, and then she appealed again to the United States Supreme Court, and they ruled in favor of her, overturning her conviction, and basically came out with a ruling that said, hey, states too have to abide by the Fourth Amendment.
And the issue, I suspect, is that they weren't searching for the obscene material,
right?
And so they weren't allowed to find it. They were only allowed to search for what they said they were looking for.
Right.
Yeah.
And I think in this particular case, they didn't even have a warrant to go in there looking for the bombing suspect or the illegal gambling paraphernalia. They didn't have a warrant at all.
And it made it all the way up to the Ohio Supreme Court.
Yeah.
Huh. That's interesting.
And I think that changed the course of that amendment as it applies to citizens. It's just an incredible change in interpretation.
And what year was that?
That was 1961.
That's pretty late.
Yeah. What's interesting is so many of them that had an impact on the way we think today happened in the 60s. There was one, I think, around the same time, Aguilar versus Texas. We could have done an hour-long show on all of these and the impact that they have on our interpretation of the Fourth Amendment as it applies today.
Interesting.
Another one, 1967, this one might be a lot more familiar to everyone, and this is Clatts versus the United States. And this ruled that the Fourth Amendment protects a person's privacy, not just their physical property. You and I talk about this a lot.
Yeah. As much as I'm a privacy advocate, it doesn't really say that, unfortunately. And I wish we had one that did say that. But it really doesn't say privacy. It just says they can't search and seize. Yeah.
I think, let me cover what happened in this one, and then I'm going to go back and give you some thoughts on that. So in this particular case, the FBI attached a wiretap to a public phone used by Charles Katz, and they used his recordings to convict him of illegal gambling. And so he took this all the way to the Supreme Court, and the court ruled in his favor and said that he had a reasonable expectation of privacy. And so that's where we get this idea now where Americans say, I've got a right to privacy.
Right.
And you and I argue that, no, you don't, because it's not really written in the Constitution.
Yeah.
We wish it were there,
but
it's not really there. And I think that was very similar to me to like Roe v. Wade.
Yeah.
And I think the overturning of Roe v. Wade was the right decision because because it's not in the Constitution. It's not in the Bill of Rights. And so it put it back in the state courts where it belongs. Let the state decide.
Yeah.
Or I shouldn't even say the courts, the state legislatures should decide. And in this particular case, I feel the same way. I feel like the Supreme Court at that time in 1967 read into the Bill of Rights something that was not there but should be.
Yeah. Yeah. Do you know if in that case they had a warrant? I guess they didn't, right?
I don't believe so.
Yeah. Yeah. So I guess I always assume that all the warrants and stuff that people talk about go back a lot further, but I guess they really come from the 60s.
I think we're about to have some...
I'm just so curious. Do you have to have a warrant for something that is public property, though? If it was a public... Because you said it was a public phone, correct?
Yes, it was a payphone, yeah.
If it's not your own personal property, you wouldn't have to have a warrant.
I think they were playing out, though, on the expectation of privacy, which is vague.
Yeah, that's a stretch.
But I think that's what they were saying, is that when you pick up a phone to use, you expect not to have people listening in on it.
I don't know if it's because we're in a different time frame where so many people say that our phones are listening to us all the time.
Yeah.
And so we already have that in our head of expectation that it's not. But I don't know. It just makes me think. I'm like, that doesn't sound right.
No, it doesn't. Well, isn't it the case that if you're in public and somebody's out taking photos, you might be in it, and you can't reasonably expect to not be in a photo if somebody wants to get a shot of, say, downtown Boerne?
True.
So that seems like a contradiction there, right?
Yeah. But part of this is also the sort of evolving society. Back in the day, they didn't have cameras on everybody, and they didn't have phones everywhere. And so they said, if I'm here and it's just me and I'm talking with one other person, I should expect that nobody's there. And they extended that to cover phones, which was a new technology. And now our smartphones are newer technology. And I think it just goes to the Bill of Rights was written with certain societal expectations and understandings, but we've grown and changed, and we're trying to take the same wording and apply it to now. I suspect if they wrote it back then and they had cell phones, they would have worded it quite a bit differently.
In
And I wish we would go back and reword it.
Right. In 1967, a lot of people in the United States, and this is going to be hard to believe, but a lot of people still had party lines.
Yes.
And so I laugh at the idea that you have a reasonable expectation of privacy, because anybody that's ever been on a party line would know that you almost expect.
Aunt June is always listening.
Exactly.
Yes.
Yeah.
Yes.
Somebody is listening in.
Yeah. Yeah. Let's see. But maybe they didn't have them in cities. I don't know, but that's a good point, because really he couldn't have expected privacy if they all had party lines.
I don't think in the cities, because I think that was a
much.
rural.
It was, but still.
Yeah, the idea that I'm
there.
on a public phone, and which usually in those days meant that you were in a booth that had not soundproof glass. It's not like the studio that we're in now. I don't know that you really could expect that conversation to be private.
Yeah. That makes me wonder, this phrase, an expectation of privacy, is that a concept that maybe was promoted by the courts and has entered our society more from the courts than from anywhere else? Because people didn't expect privacy on party lines.
I think so. I think, and again, that points back to Roe v. Wade, and a lot of what we saw from the U.S. Supreme Court in the 60s is that there was a lot of wishful thinking. This should have been in there, so we're going to put it in there. Unlike today's Supreme Court, which I think is very originalist in nature. Hey, it's not there. It's not there. Yeah. I'm not going to read into it what's not there. And I prefer that. Now, if we could be that way, then we'd lose our right to privacy. And I don't want that, but I think that would force us to take it back, or take that issue where it belongs, which is to the Congress, and say, give us that.
Yes.
You know?
And they could do that. All these things that the courts try and move into the public sphere could be gotten there by the legislature if they wanted to. Unfortunately, they don't.
Yeah.
I mean, we could have a right to privacy in America if the legislator came up there and passed it and signed it into law and said, okay, everybody has a right to privacy on their phones, or here or there or everywhere. And but they don't, because that's a lever of power that's hard to give up.
Yeah. And I think what the proponents of Roe v. Wade have learned is that what 9 people in black robes can give you, 9 people in black robes can take away from you.
Yeah.
And that's a good reason to not have our right to privacy given to us by 9 guys in robes.
Right. Because in the case of Roe v. Wade, we had 50 years of strife.
Yeah.
It's just on and on. Other countries did not have that.
Yeah.
Because whatever rules they came up with tended to be done through their legislature rather than through their courts. Not all, but a lot of them were. And they reached some sort of compromise. Now, honestly, I don't know what they all were. But now we're going through that finally. And it's contentious. And every state's going to try different things. But it's much better than 9 guys.
Right. No, absolutely.
So we're going to take a quick break. This is Ceasefire with Dale and Ron. We'll come back and talk a little bit more about searches, seizures, and maybe a little bit of privacy. Boerne has its own bookshop. In fact, it's called the Boerne Bookshop. Hi, I'm Dale Adams, inviting you to get lost. Get lost in a good book in our relaxed and casual atmosphere. We have a wide and eclectic selection in the Boerne Bookshop, and we pride ourselves on finding what you're looking for. We do author meet and greets, host writing workshops, and can connect you with a good book club. And your young ones will absolutely love our kids section at the Boerne Bookshop. And while we want you to get lost, We're easy to find, as we're in the heart of Boerne, at the back of the Richter Tavern building. We are the Boerne Bookshop. Welcome back to Ceasefire with Dale and Ron. We are talking about the Fourth Amendment and unreasonable searches and seizures, and we've drifted off into talking about privacy, which sounds like it should be the same, but it technically is different.
Yeah.
In what way would you say that they are the same?
Oh, that's a really good question.
Okay, I would say that the searches and seizures protections is a subset of privacy, and that they apply to physical things within your home, but it doesn't apply to everything. We don't have a right to privacy anywhere and everywhere. We have a right to privacy when it concerns some papers that we have in a folder in our desk. We have a right to keep in our closet what we want to keep in our closet and not have somebody look for it, but not necessarily all the rest of it.
I think it is a restriction for power, personally.
Oh, yeah.
I see it more on the outside, not for the individual person, but for the actual government to not be having too much power in their hands.
Mm-hmm.
That's a good point, because it's easy to forget that the amendments, the Bill of Rights, is not actually about our rights. It's about limits on the government. They say the government shall not infringe our right to speak. It doesn't say we have a right to speak. It says it shall not infringe. It doesn't say we have a right to privacy. It says the government shall not search for things without probable cause. That's a really good point, Lexi. Yeah.
Yeah. That brings me to another Supreme Court case, and this one, it gives me a little bit of consternation as well. And this one is Terry v. Ohio, and this was 1968. And this is a big case, too. This one established the constitutionality of police stop and frisk procedures. And basically, the ruling allows police to interrogate and search suspicious people without probable cause.
Yeah.
And that one gives me a little bit of trouble. I grew up in a neighborhood when I was in high school that had a very strong police force, something that I would appreciate now as an adult. You know, because they were always out on patrol, and so it was a very safe neighborhood. As a young kid, I hated it. I felt we were stereotyped. So there are some young people, we're going to pull them over, and I can't tell you how many times I would get pulled over, not violating the law, no traffic violations, but just they pull you over, ask a ton of questions, looking for something.
Yeah.
You know, in one case, I was sitting in the back seat of a friend's car, and my brother was in the passenger seat in the front, and we get pulled over, and hey, I thought I saw you bend over and put something underneath the driver's seat. And I'm like, no, I didn't do anything of that sort. And oh, you have any beer? No. You know, it's just the question after question.
Yeah, yeah. And that's their conversation to see if there's probable cause.
Right.
Yeah.
Right.
Yeah.
Like you said earlier, it's too bad we don't have somebody here from law enforcement so we could ask them about that.
Yeah.
But that always frustrated me. And I always thought that the court stretched on this one too, like they stretched on the last one. I have... You're going to tell me the year before that I have an expectation of privacy, but then you're going to tell the police that without probable cause, they can stop and frisk me.
Yeah.
And the stuff that I have in my pockets, wouldn't that be my personal property that you're telling me in the Bill of Rights, you can't have access to it without a warrant?
Yeah. You'd think that.
Yeah.
I think this leads up to the issue with having 9 white guys decide how things are interpreted. Since the law is not really clear on exactly that, you'll have one judge push one way, one judge push another way, and over time you may come to some sort of balance, but you're having it done by judges going back and forth rather than by legislators debating issues and trying out laws and stuff like that. And that's one of the problems we have with judges that don't look at the law simply and just rule based on intent and original writing and stuff.
Clarence Thomas said, I believe it was last year or the year before when they ruled on Roe v. Wade, that he really wanted to open up a lot of other cases from the past and take a new look at them, and that alarmed a lot of people.
Yeah,
I wasn't alarmed because of cases like this, like the two that we've just mentioned.
Yeah.
Hey, let's take some of these things that we've just taken and say, yeah, okay, that's it, that's law. And let's review them once again under a set of new eyes with that originalist interpretation and say, okay, let's make this better. Let's force the legislators to deal with this.
Yeah. And that's one of the problems with law by precedent. We look at laws and they say, okay, it was decided this way 50 years ago, 100 years ago, so we have to look at it the same way. It's always bothered me that a lot of legal scholars and experts and whatnot focus on precedent as to how things should be determined. Whereas, in my view, it should always be determined by whatever the law is. Whatever it's written down should be done that way. And, don't quote me on this, all you people out there. But I seem to remember one of the old Harvard Law School deans back in 1920s decided to change the way he was teaching law from written law to precedent law. And I don't remember exactly the whole details, but at that point in time, there seemed to have been a transition to focus more on how have judges ruled in the past into how we should rule now, rather than what's written, how do I interpret it, and that's the way we should do it. And so I think this whole going to precedent has caused a lot of problems like this.
I agree. And the way we thought 100 years ago is very different from the way that we think today.
Yes.
So if we rely on precedent, this is the way we've always done it, then there's some things that we'd still be doing today that wouldn't jive with the Constitution. Yeah.
And it also discourages people from writing clear laws. Because if you follow the law as it's written and it always screws you up, you're going to go back and you say, okay, we're going to rewrite this law and phrase it differently. And then it gets done right. And as times change, you can change that. But precedent doesn't change, because precedent implies you're following something set down on a particular day 150 years ago. Yeah. Okay, we're going to move on to the book of the week, which is entitled Why Privacy Matters by Neil Richards. This is a very current book, and it talks a lot about social media and technology and all that kind of stuff. And so I thought, okay, we may not have an amendment that addresses this, but we do have a book. We got it at the Boerne Bookshop. You can stop by and pick it up. And I would like to see more people interested in privacy.
It looks like you got another book there.
Oh, this is my handy behind the Bill of Rights.
Oh.
Every time we talk about the Bill of Rights, I bring this because it's got a whole chapter on each one, and so I can flip through it. And
who's the author on that?
Bill Norton and Jeremy Nelson.
Oh.
We actually have a whole section on constitutional studies and stuff like that.
Cool.
People want to stop by and check them out.
All right.
Yeah. So one question I've got is, why don't we have a right to privacy? Why didn't the Fourth Amendment said the right to privacy shall not be violated, as such the government can't do this and this? On the First Amendment, they say that. The right to, or I can't remember. I'm not going to look it up.
I think it has a lot to do with the time. I don't think that the Founding Fathers could think in the terms that we think of today when we talk about privacy. They didn't have the technology that we have. I think that the Supreme Court in 1967 was trying to do the right thing. I think at that point a lot of people had been thinking about that privacy is more than just our personal effects in our home, especially as we became a more mobile society. I think that extension of thought makes sense. It's just not written.
Right. Back 250 years ago, everything was localized and everything was physical. There was no virtual, there was no electronic, there was no away. Everything was immediate and right around you. So they could make the laws of the Constitution, the amendments like that. Yeah.
Well, Dale, this has been another great show that should have been an hour long.
Yes, we can go on and on.
Hey, folks, if you like what you hear on the show and you want to get some more of it, Dale and I would like to invite you to Whiskey and Wisdom, a new book club that started late last year, and we meet every other month.
And that would be the third Thursday of April, June, August, October, and December.
Please join us. We're going to have an assortment of whiskeys there and a great conversation about a very interesting book. Hope to see you there.
Thank you for listening to Ceasefire with Dale and Ron. And if you missed any of that, you can go back and listen to it at BoerneRadio.com or even listen to any of our old shows. Thank you for listening, and we'll see you next week. Boerne has its own bookshop. In fact, it's called the Boerne Bookshop. Hi, I'm Dale Adams, inviting you to get lost. Get lost in a good book in our relaxed and casual atmosphere. We have a wide and eclectic selection in the Boerne Bookshop. We pride ourselves on finding what you are looking for. We do author meet and greets, host writing workshops, and can connect you with a good book club. And your young ones will absolutely love our kids section at the Boerne Bookshop. And while we want you to get lost, we're easy to find, as we're in the heart of Boerne at the back of the Richter Tavern building. We are the Boerne Bookshop.